Howdy, and here we are, into chapter 2 with video 4. And we've got a lot to cover here, but you've heard this last week. Last week I listed some common law causes of action. Remember, common law causes of action for these types of cases or controversy are state laws. They're state laws, they're state court decisions. So contract breach, breach of implied warranty, and all this, it's going to be common law. It's going to have come down through court decisions. And I'm going to walk you through some of the elements of this. One you'll hear quite a bit in data breaches is contract breach. So, hey, MasterCard, I had a contract with you, or the bank, I had a contract with you, or Mr. Stockbroker, I had a contract with you. Now, the first thing if I sue you for data breach is the defendant is going to, depending on who benefits who, but one party or the other, does a valid contract exist? And we've talked about this a little bit. There has to be consideration between two parties. All right, well, a valid contract exists. You know, you're running my charges. You're keeping 1% from the merchant. You've got the control of my money. There's not many questions here. Now, then we ask ourselves, are the terms and conditions of the contract invalid as contrary to public policy? Okay, we've talked about this. Void of public policy. So I might have a contract that's valid that I got you to sign, but it could be so harsh that a judge would rule this is contrary to public policy because for some reason our public policy is to, for instance, in a non-compete, not to hold you to 10 years because our public policy is to encourage job growth and participation in the economy, and that would chill that. Now, I want you to be sure that you get the damages here. The damages is to put the defendant back as before the contract was in place. So you hire me to do something, you give me $10,000, I don't do it, I lose the suit, I pay you your $10,000. Now what you need to know is that you sign a contract every time you click to accept terms and conditions and or with a credit card transaction. And one of the problems we're not going to talk about a lot now, but you should put on your radar is the problem with arbitration. Now that what negates everything I've told you about filing a lawsuit, because you were heard before 3 arbitrators typically. And within the last, couple of weeks, the Supreme Court of the United States ruled unanimously that the arbitration clause were binding. I think it was a unanimous decision. So what I want you to know is contract breach is we have a contract, there's consideration. Is there a valid contract? Yes. Are we going to make it invalid as contrary to public policy? But the damages are limited. It's going to put the party back to where it was before the contract was breached. Now, another good one is a tort of negligence. I'm driving down the street on the wrong side of the street on my phone. I hit your car. Well, was I owed a duty? Were you owed a duty by me? Yes, to drive safely. And did I breach that duty? Yes, I was driving down the wrong side of the street on my phone. And was the damage to your car done by my behavior? Yes. And is there an injury? Okay. Now, negligence uses the reasonable person standard. Was it reasonable for me to be driving down the street playing on my phone? No. So we have to have 4 elements. Was the plaintiff owed a duty? Did the defendant breach that duty? Did the defendant's behavior cause that injury? And is there an actual injury to the plaintiff? So I'm driving down the wrong side of the street, playing on my phone, and you're sitting in your front yard, and nothing bad happens. Yeah, you owed a duty. Yeah, I breached that duty, but there wasn't an injury caused by my bad behavior. Now, negligence can include damages, exemplary damages, and also what's called punitive damages. So I'm grossly negligent. I'm blindfolded, drunk, driving in a school zone. Okay, so they say not only are you going to pay for all the damage you caused, but we're gonna punish you and make you pay more. So here's where it becomes interesting in cybersecurity. And when we reach out and try to look at the law and apply it to cyber, we have to think, could we use that negligence standard? What if there wasn't a contract? We can't use contract. But was there some duty that some reasonable person would have seen? And one of the, to look at whether the duty exists, and we go back to our 4 elements here, is owed a duty and the defendant breached that duty, was there harm foreseeable? If I'm driving blindfolded in a school zone, speeding on my phone, you can pretty much say bad things are going to happen. Or if I'm driving down the wrong side of the street in front of your house, right? So a duty exists. Is there a connection between the defendant's conduct and the injury suffered? And is there some moral blame? And by moral blame, we mean, were you bad? Were you bad? Was that a bad thing to do? And we talk about a public policy of preventing future harm. So a lot of times in your original torts cases on negligent, things like refrigerators catching fire, some weird things, barges coming undone and going downstream in a storm and downriver and hitting the stuff and everything. We want to put in and cause people to recognize that they have this duty so they will be more careful. And so that creates a burden to the community to impose a duty to exercise care. Okay, so we know that if you're driving down the wrong side of the street, playing on your phone, and you cause an accident, well, you know what? We're going to be more careful, or we're going to tie that boat up, or we're going to do something else. So the whole tort law is an interesting kind of law. It allows for more damages. You have this 4-prong, and it is basically we want to prevent future harm. We want to have these cases. We want to punish people because then we're going to have a burden to the defendant and the community at large to exercise care. Now, I'm not going to go into this economic loss doctrine. It's in your book. But again, it goes to state common law, negligence claims. It differs by state. What constitutes this? Not important for this class. But it does usually require physical injury or property damage, and not just an economic paper loss, right? I had to have been hurt, or there was property hurt, and not just saying, because that car happened, or that accident happened, I was late for work, so I lost an hour, something like that, being paid. Was I hurt? Was there property damage? Another case we're seeing more and more used in data cases is negligent misrepresentation or omission. If you put in writing you're going to protect data, you better have your data protection in line. This is actually a catch-22 because you can actually put it in writing that you're going to protect data and then have that used against you when you have a data breach by saying, hey, you said you were going to do it. Where was it? In Target's case, they failed to disclose material weaknesses in the data security systems and procedures. So the card holders held that this was negligent misrepresentation or omission. They should have done this differently. Kind of a different take. I'm more the torts person, but this when you're going after cases, you get as many of these types of points as you can, just in case one of them gets overruled. So we've talked about causation, the connection between the defendant's contact and injury. Can it be proven that the breach of duty caused the injury? Okay, now I'm talking breach of duty, not breach of data here. We're just using the same word, breach. But does the data actually cause the injury? So sometimes something will happen and there's not a clear chain, okay? And so just by events occurring within weeks of each other, you can't prove that breach of duty caused the injury. Okay, another common law cause of action is breach of implied warranty. There's something called the UCC, and it basically covers the sales of goods. Now, what's been happening lately is maybe that means goods actually meant goods and services. And it basically says there's an implied warranty. Even if there's not a warranty, it's implied. And Massachusetts particularly, the courts are very lenient on, hey, yeah, there's an implied warranty. All right? So you have this fitness for particular cars, merchantability, and all this. My whole point of this isn't to get caught up in the UCC code or how it's being applied, is to make this salient point. We are using existing laws for the sale of goods and not services in data breaches. Okay, we're using existing laws. Basically, we are saying these are goods, your data is a good, And we're using this now, this breach of implied warranty, which was not the purpose for which it was set up. We talked a little bit about evasion of privacy. Unjust enrichment is where I unjustly benefit. I steal money from you. I invest it. Let's say it's through a contract breach. You get your money back with statutory interest, but in the meantime, I've doubled your money. That's unjust enrichment. It's not fair for me to keep that. Now, we're not going to talk too much about this. Class action lawsuits, we'll get about this later. Classes must be certified, Federal Rule of Civil Procedure. Most are federal suits and cyber for interstate commerce. Like I said before, class action lawsuits in Texas almost never happens. We're not going to talk that much about insurance now. We'll save that topic for the end. That's more for my risk class. Okay, but here's the key takeaways as you study and think about Chapter 2. Data breach law is unsettled. We don't know where we're going. We have inconsistencies between federal appellate districts, the circuits. Okay? If the Supreme Court doesn't make generally widely applicable rulings, then guess what? We have to deal with that situation. We have to deal with the differences in jurisdiction under the Seventh Circuit as opposed to the Third Circuit, in my previous example. And we're also attempting to use state common law that's in existence, such as the UCC, for mixed results. Go back to this map. Chapter 2, for now, skip the reading on class actions, insurance privileges. Kind of not skip it so much as skim it. It talks about attorney-client privilege, work product. Just know this. When I'm an attorney, but I'm talking to you, we don't create an attorney-client relationship. There's no money changing hands, right? So the attorney-client privilege only can exist if there's a relationship. And it basically protects the communication between the attorney and the client unless it's waived accidentally. You hold the privilege. If I'm the attorney and there's attorney-client privilege, the client holds the privilege. But we'll talk about this in other cases. Sometimes something is done. You put a third party on an email. You're corresponding with your attorney and you want your friend who's an expert this, you have just waived attorney-client privilege. That communication is now no longer protected. Anybody can have access to it, okay? That's what I mean when you do it accidentally because you didn't know you were going to do that. Work product produced in anticipation of litigation is also protected. So there's certain kind of communications that we protect an attorney and client that may actually be, prove that what the plaintiff's case is actually happened or something. But you need to know this. You have to be very careful and you have to protect this or you lose that privilege. That's it. We're done with Chapter 2. Thank you.